All right, good morning. Welcome to the 294th District Court. My name is Judge Chris Martin. I'm going to call the morning docket. When you hear your name, please say present or here. Michael Bowman.
Here.
Brad Brewer.
Here.
Bryce Carroll.
Bryce Carroll.
Okay. Giovanni Chavez Rosales. He's here. Joshua Chenault.
Joshua Chenault.
Bradley Copeland.
Here.
Alicia Joyner.
Here.
Michael Patterson.
Michael Patterson.
Lena Price.
Here.
Andrea Pullings.
Andrea.
Kaylin Cheatham. Eugenio Gonzalez Molo. Monica Roberts.
She's here.
Thank you, Mr. Green. Jonathan Ridenour.
Jonathan Ridenour. Yes, Your Honor.
Ms. Abraham, if Mr. Ridenour will sign that notice of appearance with that 4/4 date and check in with Carl. If Carl says he's good to go, then he's good to go. He doesn't. I already granted that continuance. There's a motion for continuance followed by Mr. Harrison. The court's already granted that. I had Mr. Ridenour appear. Joshua Lee Davis, CR 22372. Show that Mr. Davis has been verified in custody in Henderson County on a federal detainer. We'll recall that one. Becky Browning Whitworth.
Judge, she's in the hall. We have paperwork.
Thank you, Ms. Rainey. Christina Ross. All right, and Mr. Murley is going to appear via Zoom today because she wasn't scheduled till Thursday, but she showed up today, so we'll go ahead and work her in. Katrina Anders. Jason Briggs.
Here.
Joseph Cronin.
Your Honor.
Joshua Hand.
Paperwork. To report on the status.
I'm sorry, I couldn't hear you.
I have paperwork on a status for you. Medical paperwork.
Okay. Kenneth Henderson. Sydney Hip.
He is here, Your Honor.
That's fine. Nathan Cathell.
Here.
Anthony Murray.
He's here, but
John Rigney.
on his way.
Michael Tuff.
Here.
Katie Williams.
No,
Thank you, sir. Kenesha Williams.
no.
John Piercefield.
John Piercefield. No, Your Honor.
Christopher McBeth. David Dawson.
Your Honor, Mr. Dawson, officer, out. But we're out.
Sandra Fletcher.
Here.
That's gonna be resolved.
Thank you, Mr. White. Daniel Payne.
He's out.
Mary Robinson. Hannah Short,
Your Honor, Ms. Short is, if you can see right now, I'm the fault. That's for the case.
okay, we'll recall that one. Isaiah Valencia Fulton,
Justice President, Your Honor, this is the hall.
thank you, sir. All right, is there anyone whose name has not been called? Do you have any attorneys that are ready?
Right.
Maybe Mr. Schmidt? Are you ready on Mr. Schmidt?
Jason Briggs.
Jason Coley Briggs, CR 22370. Mr. Briggs is set for pretrial.
That's correct. Go, it's actually the one that's set for.
All right, court will set Mr. Briggs for docket call. You filed April 4th.
Yeah.
Fine. All right, court sets Mr. Briggs for docket call April 4th at 9 a.m. Anthony Murray, CR 22336. All right, Mr. Murray set for pretrial.
Judge, yeah, we're gonna ask, help the task with this one, that we set that, call.
No pretrial motions.
Not this time.
All right, court will set Mr. Murray for docket call April 4th at 9 a.m. And once he signs, it's free to go. Sydney Hip, CR 22379, 2022-432, set for pretrial and docket call.
That's correct, Judge. So I think tentatively we have to written state.
This, where's Sydney Hip? Good.
We have a agreement to stay, this would like that's like a big. So I guess. Separate call. But I believe we're likely be ready to solve it.
All right, court will set Mr. Hip for docket call in each case on April 4th at 9 a.m. And Mr. Schmidt, I show that Mr. Hip is delinquent $120 on his pretrial release.
Pay 100 days.
Pay 100 today. Okay, all right, get that done before you leave.
Dan Henderson.
Kenneth Jerome Henderson, CR 22325, docket call. Go ahead, Mr. Schmidt.
Judge, I think we reached an agreement with the state, not even because I understand this week, but we can say we're waiting on it.
All right, court sets Mr. Henderson for plea April 4th at 9 a.m. Once he signs, it's free to go. Katrina Anders, CR 22351.
Judge, I think we said for a free trial, we don't have anything tested, I think we about to wrap her up, and we said we're not calling.
Corresponds there being no pretrial motions. Court will set Ms. Anders for docket call on April 4th. Mr. Schmidt, I see that Ms. Anders is delinquent on her pretrial release fees. Okay, how much you gonna pay them? You're delinquent 140. And you didn't report it all in February. So we're gonna drug test you today. And you pass that test, you get to go home. You don't pass that test, you're gonna stay with me. Okay, so you're not free to leave yet. I want you to go out in the hallway and see Mr. Waddell and take the drug test, okay?
Judge, the last one for now, we could, bring up Josh again.
Joshua Ray Hand, CR 21-168. You said Mr. Hand's on here.
That's correct, Judge. I talked to Mr. Ham yesterday and the problem is, it's medical paperwork next to the report, and I didn't testify, I was going with Dan, but this. One, Judge, I think this, many lot and then. Hopefully, you can run. All of them. I treated it, it's 60.
You put your COVID spray on.
Yeah. And I know there's that it wasn't a diagnosis, but it does state it's quarantine, so I presume that that's sufficient based on what I told.
All right, court will reset Mr. Hands. Some motion to revoke, correct?
Yes.
All right, court will set Mr. Hand for the contested docket on March 30th. Does Ms. Fabian have a copy of this?
I know she doesn't answer.
You'll give her a copy of that. Yes, I'm gonna get it.
Maybe what's the question is possible.
All right, Mr. Brewer, this is cause number CR 23-6. Here's that you have been charged by the grand jury with a state jail felony offense of theft of property greater than or equal to $2,500 less than $30,000. Do you intend to hire an attorney? Are you requesting a court-appointed attorney? Are you wanting to represent yourself? Okay, and tell me why you're wanting to represent yourself.
There's no reason to call the county for money. Yes. Tax evasion, tax evasion.
Okay, and do you understand that in representing yourself, if the court allows you to do that, then you would be held to the same evidentiary standards and legal procedures that any other attorneys who enter this courtroom would be required to adhere to. You understand that? And you understand that you would be opposed by the state's attorneys who are licensed in the state of Texas, have been through law school, understand the rules of evidence and the rules of procedure, and they would be your adversaries. Do you understand that? Have you ever represented yourself before?
No.
And you don't have the means to hire an attorney?
No.
And have you really thought through this
Yes.
decision?
Yes.
All right, have a seat. There's a form I'm going to print out. I'm going to have you read over that, and then we're going to talk about some themes such as your level of education, your experience with the legal system, things of that nature. Okay, so have a seat. I'll call you back up in a moment. Ms. Abraham. Michael Bowman. CR 23-5. Mr. Bowman, you've been charged by indictment with a third-degree felony offense of evading arrest or detention with a vehicle. If convicted and sentenced, that carries a range of punishment of not less than 2 years in prison, up to 10 years in prison. How do you intend to proceed with regards to an attorney?
Well,
Okay, and how long would it take you to hire an attorney? Do you know? Couple of weeks. So if I give you a 30-day reset, you feel confident you can hire an attorney to represent you? Okay. All right, Mr. Bowman, the court's going to reset you for arraignment and status on hiring your attorney on April 4th at 9 a.m. All right, we'll see you back on April 4th, okay? So we do me a favor, we just, Miss Christina Ross is in the hallway, we just ask her to come in, Christina Ross.
Hey.
Good morning, Mr. Murray Leader.
Good morning, Judge. How are you?
Hey, I'm doing fine. I appreciate you working us in for Miss Ross. I did see the sense in making her come back on Thursday since she made this trip. So I'm going to call the case. This is CR 21-143, State versus Christina Ross. Ms. Ross is present in the courtroom. Mr. Murray Leader is appearing via Zoom with court permission. And I think we're just on a status for Ms. Ross. Anything from the defense or the state on Ms. Ross?
Your Honor, just that the case that we're waiting on, especially set in December now, So, you know, we are gonna remain the same status on Mr. Ross. She is here in person today, so we would waive her appearance at the next, we would agree to waive her appearance if the court deems it at her next meeting.
Is Mr. Waddell outside? Mr. Waddell, I'm sorry to bother you. I know you're extremely busy. We're making an announcement on Ms. Ross. Is there any concerns from pretrial release with regard to Ms. Ross's compliance with pretrial release at this time?
Yes.
Can you tell me about that? And can you come over here a little closer, just so Mr. Murray, I know that he can hear you. He's appearing via Zoom. Go ahead.
Yes, she has tried to share information of her physical condition and other situations of living in Tennessee. And has been good to report and stay in touch. And is trying to get current on her fees.
Is there any opposition to Ms. Ross appearing remotely, say every other court appearance? I mean, do you have any concerns that should prevent her from appearing via Zoom or remotely?
No, sir.
Okay. All right. Thank you, sir.
Okay.
All right, Ms. Ross, I'm going to set you for your next hearing on Mr. Murray, are you available on Tuesday, May 9th?
Yes, Your Honor.
Okay, all right. So Ms. Ross, I'm going to set you for status on May 9th. And I'm going to allow you to appear via Zoom that day unless we notify you before that, which will be in person. If we notify you to be in person, we'll give you advance notice. Okay, so if you'll continue to stay in compliance and reporting to Mr. Waddell and doing what you're supposed to be doing, then we can allow you to appear remotely. If at any time the court has a concern that you're not in compliance, I'm going to bring you back. Okay. They did. They did. All right, Mr. Murray, then she's reset for status, May 9th at 9 a.m. So if you don't have anything further, you're free to go, sir.
Yes, Your Honor. Thank you very much, and thank you for accommodating us, Judge.
Well, hey, you're welcome. Thank you for squeezing us in. We'll see you.
Bye-bye.
You're welcome. You ready?
Yes, Judge.
Yes. Who are you ready on? I'm sorry, I didn't hear that.
This Browning.
Becky Browning Whitworth, CR 22-318.
Oh,
All right, Miss. Do you go by Browning? Do you go by Whitworth, or do you go by Browning? All right, Miss Browning, if you'll raise your right hand, I'm going to place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you can lower your hand. Your name is Becky Browning Whitworth, is that correct? And Miss Browning, are you a United States citizen? Do you read, write, and speak English?
Yes, I do.
And have you ever been diagnosed with a mental condition?
No.
In this case, you're represented by your attorney, Mr. Jonathan Manning.
Yes, sir.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you happy with his representation of
Yes,
you?
sir.
Do you feel like you've had enough time to talk with him about your case and you've had all of your legal questions answered?
Absolutely.
Is there anything about the paperwork that you've read and signed today that you do not understand? Mr. Manning, do you believe Ms. Browning to be competent today?
She is, Judge.
And you explained to her rights and all of the consequences of her plea? And you believe that she understands her rights and that she's entering into this plea intentionally, knowingly, and voluntarily?
I do.
All right, Ms. Browning, I see that you were originally charged with an felony offense of obstruction or retaliation, a third-degree felony. However, the plea agreement today before the court is that you would plead guilty to a lesser included offense of false report or statement to a police officer or agent, a Class B misdemeanor, which would carry a range of punishment of not more than 180 days in jail and an optional fine of not more than $2,000. I see the plea agreement is that you would plead guilty to that lesser charge in exchange for the state's recommendation that your punishment be conviction plus 1 day confinement in the county jail, and you would receive credit for time already served of 1 day. In addition, a $500 fine plus court costs and reimbursement fees. Is that your understanding of the plea agreement?
Yes.
All right, then, Ms. Whitworth, I'm going to ask you, how do you plead to the lesser offense of false report or statement to an officer, a Class B misdemeanor?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime and for no other reason?
Yes, sir.
Has anyone ever threatened, forced, or pressured you to plead guilty today to this crime? All right, the court will accept the defendant's plea. Mr. Manning, any objection to the state's evidence?
No objection to state's evidence, as well.
All right, state's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor, we addressed it.
From the defense?
Just really, Judge, Ms. Browning and I discussed potential defenses extensively. Ms. Browning, due to many life circumstances, has a high level of anxiety. She's very nervous to be here today. But she does understand the plea that's before the court. She has decided that the best resolution and outcome for her, and she's ready to put this behind her.
Thank you, Mr. Manning. All right, the court's going to review the evidence. All right, the court has reviewed the evidence. I find sufficient evidence to convict the defendant of this offense. The court takes judicial notice of Ms. Browning's judicial confession. Based on the evidence, the court will follow the plea agreement between the defendant and the state. Court hereby convicts Becky Browning Whitworth of false report or statement to a police officer, a Class B misdemeanor. The court assesses her punishment at 1 day confinement in the county jail, gives her credit for time served. Court orders her to pay a $500 fine, $270 court cost, and $590 reimbursement fees. All right, Mrs. Browning, are you going to be able to pay off your fines and court costs today?
No, Judge, she is on a fixed income, and she is, made plans to set that out each month as her check comes in, she have that sort of auto pay bills. But she is going to go upstairs and set them down.
All right, and you understand that if you don't uphold the agreement to pay, that the court will issue a warrant for your arrest? Okay, all right, then, deputy here is going to take your fingerprint. After you get that, then go up and see Ms. Harmon about your court costs and payment plan, okay? You ready? You ready?
Almost, my client is running a little late.
Okay.
Should be here in the next 2 or 3 minutes.
Mr. Manning, you ready on anyone else?
Judge, that's all I have today. I think.
Oh, that's all you have? Okay, yes, sir. It's not your usual day anyway, so.
No, that's what that is right.
All right. Mr. Copeland? This is a sanctions court hearing on Bradley James Copeland. All right, Mr. Copeland, last time we were here, we talked about community service. You got all your community service done. Tell you what, I want to do what we did last time one more time. Okay, another 30 hours of community service. And if you don't get that done, every 10 hours you don't do is a day in jail. Just like we did last time. You do that one more time, show me that you're gonna, do what you're supposed to do. I think we can get you out of sanctions court after the next 7. That makes sense?
Is there any way that I can do this on my days off?
I don't know, can you? Have you talked to, have you talked?
A month away and just talking to this time. In my middle of my year. And
Have you-
I work 3.5 hours. I've been up since 10 o'clock.
Have you talked to your probation officer
Um,
when to do your community service? I don't-
The community service is fine.
You're talking about the court appearance?
Yeah.
Sure, we can do that. Tell me when you're gonna be off again. I don't want to interfere with your job if I don't have to. Which, this is where most of appearance something about on it. Well, these pins too. These little pins don't go through.
April 12th.
April 12th, you're off that week. Are you working on April 25th? Are you working that week? What's that?
I'm fired.
Look at April 4th, 6th, 25th, 27th.
I'll be able to do this one. After the 14th, I cannot deny that. I have to. We're saying, what they, sorry.
So you want to look after April 14th, is that what you said, right?
Yes,
All right, so look at these 2 dates, April 25th and 27th. Can you do either one of those days? Why are you not working?
no, we're not able to do it. That's the day I go back to it.
That's the day you go back. All right, give me a second here. When do you get back to town after that hitch?
I believe it's gonna be 14 days from, 2 weeks from that.
Okay.
So the ninth,
You'll be back on the 9th?
I believe,
All right, so let's do this. How about 2 days after that, May 11th?
I hate to set this up, but I don't know. Know what I mean? I'm sorry, I'm very tired.
It's okay. Take your time. So are you home for 2 weeks right now?
No, sir. I get off on the 14th.
March 14th? And
Yes, sir.
and you're home for 2 weeks?
Yes, sir. Maybe a lot of you. Can do that.
When do you go back on the 28th?
Yes, sir.
You go back on the 28th, you leave out, or you have to be there on the 28th?
I have to be there. I usually think about
Leave out one time.
that evening.
The evening of the 28th?
Yes, sir.
Well, how about this? What if we do March?
No, the evening of the 27th.
The evening of the 27th? Then you should be back on April 25th. Right? You go out, if you're on the 28th through the 4th, 11th, you get back on the 11th and you're off for 2 weeks.
Yes, sir.
So you should be back on April 25th.
Yes, sir.
All right, well, let's do that then. Let's set you for April 25th. And if you get this done, I think there's a good opportunity for you, for your probation officer to say, if he gets all this done well before that, there's a good chance that they'll tell me that they don't even want you in court and we can cancel that hearing altogether. All we're trying to do is get you back on track where you're handling this stuff on your own without me having to babysit you.
Yes, sir.
Okay?
Yeah, I can definitely do it after, this next day is all the 14th to the 28th. I can have that done.
Okay. All right, so Deputy Woos is gonna give this to you, sign right there on the X. I'm gonna give you a copy of that. Chad, I don't think I dated today's date on that, but after he signs, he'll date that for me. I put 25th, right? 4/25. All right, get all that done, talk to your probation officer, and then I'll see you back on the 25th unless they tell me they don't want you here. Okay, all right, you're welcome. Mr. White, are you ready?
Yes, ma'am.
Mr. McBee. It's McBee, not McBeth, right? I know I've heard it over the years. I've heard it different ways. I can never remember. So always go with the spelling. I'm sorry, Mr. McBeth. All right, Mr. McBeth, if you'll raise your right hand, I'm going to place you under oath. This is cause number CR 22-358, CR 14-143. And CR 14-302. Mr. McBeth, do you swear that the information, I'm sorry, do you swear that the testimony information you give the court today will be the truth, the whole truth, and nothing but the truth? So help you God. All right, Dave, lower your name. All right, Mr. McBeth, in cause number CR 22-358, you are charged with the third-degree felony offense of possession of a controlled substance in penalty group 1 between 1 grams and 4 grams. That is a third-degree felony. Mr. McBeth, are you a United States citizen who reads, writes, and speaks English? Have you ever been diagnosed with a mental condition? In this case, you're represented by your attorney, Mr. Jeff White. Are you pleased with Mr. White as your attorney? Do you feel like you've had enough time to talk with him about your case and have all of your legal questions answered? Is there anything about the paperwork that you've read and signed today that you do not understand? The plea agreement appears to be in CR 22-358. That upon your plea of guilty, I'm sorry, you're going to plead no contest. The state's recommendation is that the court hear the evidence, convict you of that evidence, convict you of the offense, assess your punishment at 10 years confinement in the Texas Department of Criminal Justice, suspend that sentence, place you on community supervision for 74 months, order you to pay restitution, court costs, and reimbursement fees. And for your any time here to run concurrent with cause number CR 14-143 and CR 14-302. Is that your understanding of the plea, Mr. McBeth? Mr. McBeth? And Mr. White, have you explained all of the paperwork to your client?
I have, Your Honor, I believe I'll get the
Thank you, sir. And it looks like in CR 14-143, CR 14-302, there's an agreement as to the conditions of community supervision, wherein some court costs will be amended, and also that you would be ordered to submit to the county jail for some time to be served, 173 days, in which you would get credit for that time because you've already served that. So you understand, Mr. McBeth, if you are subsequently filed on for a revocation, if the court hears the evidence, finds that you violated, and if the court revokes your community supervision and sentences you to any term of confinement, you would not receive credit for any of those 173 days. You understand that? Understanding all that, you still wish to go forward with this plea? All right, Mr. McBeth, then how do you plead to the third degree felony offense of possession of a controlled substance, penalty group 1 gram to 4 grams? And you understand that a no contest plea, if supported by evidence, would be treated like a guilty plea before the court? And has anyone threatened, forced, or pressured you to plead no contest to this offense? All right, the court will accept the defendant's plea of no contest at this time. Mr. White, any objection to the state's evidence to support the plea?
No objection.
All right, states 1 is admitted and the court takes judicial notice of Mr. McBeth's no contest plea. Anything further from the state? From the defense? All right, court's going to review the evidence. All right, the court has reviewed the evidence, finds that there is enough evidence to convict Mr. McBeth of this offense. The court will follow the plea agreement in this case. The court hereby convicts Christopher James McBeth of third-degree felony offense, possession of a controlled substance in penalty group 1, greater than or equal to 1 gram, less than 4 grams. The court assesses this sentence at 10 years confinement. The Texas Department of Criminal Justice, the court suspends that sentence today, places him on 74 months community supervision, orders him to pay $180 restitution, $290 court costs, $35 reimbursement fees. Court orders the community supervision period to run concurrent with CR 14143 and CR 14302. So, Mr. McBeth, what's our plan going forward? How do you plan on doing that? Mr. White, you gotta sign that. Certificate of appeal there. I'm listening to you, Mr. McBeth. You said work, stay out of trouble. Stay out of trouble. Stay out of what? People will get you in trouble. Are you one of those people that other people are trying to stay away from? You hope not. You have family? Kids? No kids? Got a mother and a father? She worry about you? She worry about you when she doesn't know where you're at, anytime that you're in jail? Yeah. Well, you don't have to imagine so. If she's your mother, I guarantee you that she's worried about you. All right, Mr. McBeth. Mr. White has done you a good job. The state has been gracious enough to put you back on community supervision. I'm not sure that you would have gotten this on any other day, so you ought to be thankful for the gift that you got today. When you walk out of here, you ought to see it as a gift and not as a pain in your life to be on community supervision. So if you violate any of the terms of your community supervision, the court has already assessed your sentence. What is that sentence? All right, so if you violate your community supervision, the court conducts a hearing. If I find that you violated, then the only thing left to do is to be executing the sentence, not to be determining how much time between 2 to 10. It's 10. You understand that? So if you decide that you're going to violate, then you know that going into it. Understand? All right, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department, so they can carry out the terms and conditions of the sentence. Step up here with Deputy Woosley. He's going to fingerprint you and then check in with probation. Yes, thank you, Mr. White. Appreciate you, sir. All right, so is Mr. Cheatham here?
Yes, Your Honor.
Mr. Cheatham, why were you late?
When I got off Swanee.
Traffic what?
When I got off Swanee from Dallas, I guess the accident just happened. I got off all that stuff.
All right, this is cause number CR 22-205, State versus Kalen Cheatham for a docket call. Go ahead, Mr. Bellman.
Your Honor, we are very close to an agreement that we get a final docket call. I believe we can come to the agreement next time. So let's see.
All right, court, any objection from the state?
No, Your Honor, that's our understanding.
All right, court will set Mr. Cheatham for a final docket call. Are you available on April 4th?
Unless someone's playing trivia, I believe so.
April 4th at 9 a.m. Mr. Cheatham, I show that you're delinquent $50 on your pretrial release. Can you pay that today?
Yeah, all right.
You already paid that? Good. And I showed that you did not check in with your pretrial release officer in February, so you need to make sure you get that squared away with Mr. Waddell. Okay. All right, we'll see you back on April 4th at 9 a.m.
Thank you, Your Honor.
You're welcome.
My excuse.
Yes, your excuse. Mr. Stroud and Mr. White, either one of you already, or still waiting on papers?
I'm just looking to state the sign.
Judge, we're just completing our announcement form.
Okay.
Your Honor, if you're ready on I'm ready to start taking a couple.
So, who are you ready on?
Let's what I.
Hey, I know the feeling. This is Daniel Ryan Payne, CR 22-246 for docket call.
Yes, sir. If the court would call the previous pre-trial in one court that we were trying to get some VA medical records on that. I didn't ask for to push it any further. I think I provided Mr. White with some documentation. I believe if we have one more docket call that would be beneficial.
State.
States
April 4th. All right, court will set Mr. Payne for docket call April 4th at 9 a.m. All right, you're free to go. April 4th, 9 a.m. You know.
That, if you'll notice, this is a lesser included in what she's provided for, just to give you the heads up.
Who's your next one, Mr. White?
Mary Robinson.
Mary Lynn Robinson, CR 22-194. Come on up, Ms. Robinson. Good, Mr. White.
So, Your Honor, at the previous, when we had our first docket call, I had informed the court at that time that I believe there was some matters which from the discovery standpoint that we needed to address. Mr. Crawford, Ms. Melvin over at the DA's office, we finally got that stuff resolved late last week. I have not had a chance to look at the materials to the degree that I need to. I've got two new witness statements that I haven't had a chance to go through really their audio and the ECM data from the vehicle, and as well as a couple of other things. You know, Your Honor, I think if you said for April 4th, that should be 29, it's pretty good. I think everybody kind of agreed, we understand we can't do this first 2 weeks, so we said we're not.
Stay.
Thank you, Bruce.
All right, court will set final docket call April 4th. At 9 a.m. And once Ms. Robinson signs, she's free to go. You ready on that?
You want to address this short?
Short. Hannah Short, CR 22393. Court finds that she is confirmed incarcerated in TDC with a projected release date of May 30th, 2024. Are we going to be getting a bench warrant from Ms. Short? Or?
Judge, Mr. White and I are going to speak about her current sentence, and figure out how the state wants to proceed when they're meeting a short and all that.
Okay. Let's reset the report. A little more time.
Do you want to go and get it? Or are you confident we'll need one? Are you? Okay.
Let's bump it out to May and I'll give you a little more time. You available on May 9th?
Yes.
All right, we'll set Ms. Short then for status on bench warrant, plea, and arraignment. Let's do all the things on May 9th. Mr. Dawson here yet?
Oh, yes, we've already signed the paperwork.
Okay. Sandra Fletcher, CR 22272. That's fine. Hello, Ms. Fletcher. How are you? All right, this is cause number CR 22272, State versus Sandra Gail Fletcher. Ms. Fletcher, if you'll raise your right hand, I'm going to place you under oath. Ms. Fletcher, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God? Thank you, Ms. Fletcher. You can put your hand down. All right, Ms. Fletcher, I see that you want to resolve your case today by entering into what's known as a pre-trial intervention contract. And Ms. Fletcher, I just have a few questions for you. Are you a United States citizen do you read, write, and speak English? And have you ever been diagnosed with a mental condition? Okay, and you're represented today by your attorney, Mr. Nolan White. Are you pleased with Mr. White as your attorney? Do you feel like you've had enough time to talk to him about your case and that you've had all of your legal questions answered? Is there anything about the paperwork that you signed today with Mr. White that you do not understand? Mr. White, have you explained to Ms. Fletcher all of the terms and conditions involved in the pretrial intervention contract? And have you also talked to her about the rights that she would be giving up today with regards to the limited waiver of expungement rights, the waiver of jury trial, stipulation of evidence, admissibility, those things?
Your Honor, I have done in Fletcher, all the rights contained in the pre-trial intervention contract. I believe we should waive those rights and only voluntarily, with full knowledge of consequence of doing so.
All right, Ms. Fletcher, you were originally indicted with a second-degree felony offense of aggravated assault with a deadly weapon. However, I see that the agreement today is that you would enter into the pretrial intervention contract on a lesser charge of deadly conduct, discharge of a firearm for a period of 1 year. And as a part of this agreement that you want to enter into, Do you understand, Ms. Fletcher, that there's some important rights that you would be giving up? One of those rights would be the right to a trial by jury. And in giving up your right to a trial by jury, you understand that you're giving up the right to call witnesses in front of a jury. You're giving up the right to cross-examine the state's witnesses in front of a jury. You're giving up everything with regards to having a jury impaneled and sworn to hear your case and make a decision. You understand that? And you understand that you and only you can give up that right. Mr. White cannot waive it for you. I cannot make you waive it. The state cannot make you waive it. That's a right that's guaranteed to you by the Constitution. Are you giving up that right today because it's your own free will and that's what you want to do? And has anyone threatened you, forced you, or pressured you to waive your right to a trial by jury? Okay. Also, the court finds that you would be waiving your right to a speedy trial. Do you understand that? And you would also be waiving your right to have certain criminal records expunged. If you complete this pretrial intervention contract, you would be entitled to have certain records removed from your criminal history. But some records, those records belonging to the DA's office and those records belonging to the probation office, they would not be subject to being expunged or cleared because of your agreements here today. Do you understand that? All right, the court will find that Ms. Fletcher has been admonished with regards to her right to a jury trial, that she has intentionally, knowingly waived that right. Court finds that she has the assistance of counsel, that Mr. White has indicated his agreement with the waiver of the jury trial, and that the state has also agreed to waive its right to a trial by jury, and the court approves the waiver of jury trial. Court also finds that Ms. Fletcher has waived the right to speedy trial and the limited waiver of expunction. Court hereby approves Ms. Fletcher's placement on the pretrial intervention contract to the charge of deadly conduct, discharge of a firearm, a lesser offense, for a period of 1 year. Anything further from the state, Ms. Heisel?
Yes, there is a mental impact statement associated with this case that's forwarded to the court yesterday. We would just ask that you review that and try to sheet back us so we can forward it along to probation for selection.
All right, and is it the victim supportive of the plea?
Your Honor, I have not directly spoken with the victim. However, it's my understanding that he would be supportive of this.
Oh, is it in here? Okay. All right, the court has reviewed the victim impact statement. The court's going to sign the tracking form. The court will return that to the state, and then I also need the state to sign the pretrial intervention. I think it's just that one. Judge. No problem. All right, Ms. Fletcher. All right, the court has approved your pretrial intervention contract. And so at this time, I'll have you check in with the probation department, and they're going to give you more information about what's next, okay? All right.
Judge, this is the,
Oh, hang on, I got the wrong one. Oh, here it is. They were all.
We gotta sign all of them anyway,
Yeah,
but.
well, they were all, this one was connected, but it looks like. Let me move something back here. Mr. Bailey.
We have several of them today.
That's not this.
Do you need me to read them?
Let's go to the front page. Here's the rest. Pleasure. Let's see which track. Here's baby.
I can reprint the tracking sheet, yeah.
I wonder if maybe it's. Maybe check with Rachel or Karen and maybe that got stuck in that PTI stack. No, here it is, Hillary. I got it. It's on the back of baiting.
There were a couple today, so it's understandable they might get mixed up.
Yeah.
You judge.
All right, Mr. White, who are you ready on next?
Mr. Dawson.
All right, David Dawson. All right, Mr. Dawson, you'll raise your right hand, sir. I'm gonna place you under oath. You are David D. Dawson, correct? All right, Mr. Dawson, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So have you done? All right, you can lower your hand. All right, Mr. Dawson, are you a United States citizen who reads, writes, and speaks English?
Yes.
And have you ever been diagnosed with a mental condition?
No.
You're represented today by your attorney, Mr. Nolan White. Are you pleased with Mr. White as your attorney? You feel like you've had enough time to talk with him about your case, to have all your legal questions answered?
That's right.
Is there anything about any of this paperwork that you've read over and signed today that you do not understand? Okay, Mr. White, do you believe that Mr. Dawson's competent to enter into the plea agreement today?
Your Honor, I believe that Mr. Dawson is competent, that he understands the proceedings that are pending against him here today. Before the court, we have a number of waivers that we've executed out of the court that Mr. Dawson has waived his rights only when he tells us.
All right, Mr. Dawson, and cause number CR 22-324, you were indicted with the offense of fraudulent use or possession of identifying information, a third-degree felony. However, it appears that today you will resolve your cases by pleading to a misdemeanor information on the charge of unlawful use of a criminal instrument, a Class A misdemeanor. A Class A misdemeanor carries a range of punishment of time in jail not to exceed 365 days, and a fine that cannot, an optional fine if imposed, that cannot exceed $4,000. I see that the plea agreement is that you would plead guilty to the information in charge of unlawful use of a criminal instrument, a Class A misdemeanor, Your punishment recommendation is 3 days confinement in the county jail, in which you would get credit for 3 days of time already served, a $4,000 fine, and then felony cause number CR 22324 would be dismissed. In addition, you would be responsible for court costs and reimbursement fees. Is that your understanding of the plea agreement?
Yes, sir.
All right. All right, then, Mr. Dawson, understanding the range of punishment, understanding the plea agreement, how do you plead to the Class A misdemeanor offense of unlawful use of a criminal instrument? Are you pleading guilty to that crime because you are guilty of committing that crime and for no other reason? Has anyone threatened, forced, or pressured you to plead guilty today? All right, the court will accept Mr. Dawson's plea of guilt. Mr. White, is there any objection to the evidence supporting this, supporting the defendant's plea today? No. All right, then states one, in stipulation of evidence admitted, and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Just for the clarification of the record, Mr. Dawson was arrested for the crime of unlawful use of possession of criminal instrument. At the same time, we had held that charge, we have then charged that charge in your proceeding charge and take any other costs into consideration. Said, I just want to make sure, because we're not changing a charge or dropping a charge, because we're not doing that at the same time.
All right, thank you, Mr. White.
Your Honor, I'll also know, any applicable timeframes that were allotted for, preparation.
All right, thank you, Mr. White. Court will note that for the record. All right, of course, going to review the evidence briefly. All right, the court has reviewed the evidence, finds that there is sufficient evidence to convict the defendant of this offense. The court will follow the plea agreement. Court in CR 2339 convicts Mr. Dawson of the Class A misdemeanor offense of unlawful use of a criminal instrument, assesses his punishment pursuant to the plea agreement at 3 days confinement in the county jail, issues him credit for time served, orders him to pay a $4,000 fine, $270 court cost, $15 reimbursement fees, and the court dismisses under section 1245, cause number CR 22324. Court also finds that there's been an agreed judgment of forfeiture submitted in cause number SF 2110. Court finds that it is signed by all parties. And the court approves the agreed judgment of forfeiture. Court finds that $5,590 in US currency is contraband and should be forfeited to the state of Texas to be used solely for law enforcement and official purposes. The court is signing that agreed judgment today. All right, Mr. Dawson, with regards to the fine, Mr. White, is he paying that today or? Okay, all right, then, Mr. Dawson, I'm gonna have you come forward and Deputy Woosley is gonna fingerprint you. And then you can go upstairs and make arrangements for your thing, okay?
Thank you, Your Honor.
You're welcome, sir.
Yes, sir.
There we go. Take this paperwork.
Yeah, that is all you have, and you went through it. Good morning, Mr. Estrada.
Good morning, Your Honor.
All right, this is cause number CR 22-374, State versus Eugenio Gonzalez Merlo for pretrial. Go ahead, Mr. Estrada.
Your Honor, good morning. Edward Estrada, on behalf of the defendant, Mr. Eugenio Gonzalez Merlo. We are acting as local counsel, Judge. There is co-counsel, the attorney, his name is Stephen Camps. Mr. Gonzalez is out of state defendant making an appearance today for pretrial. I spoke with Mr. Amster to see if there's any pretrial motions that we need to urge. He advised that there are no pretrial motions at this time. I did pick up discovery and sent it over to Mr. Amster's office as well, Your Honor. I don't believe that there's a plea agreement at this time, but I believe Mr. Amster and the state are actively working towards reaching an agreement. If we can set this for a status, I mean, that's but there's not. And also there is two matters. There's 00374 and there's 00375.
My apologies, I didn't see that. Okay. All right, then the court finds there being no pretrial motions needing a hearing. Court will set Mr. Gonzalez for a docket call. Are you familiar with you say it's Amster?
Amster, AMSTER, Judge.
Are you familiar with his calendar at all?
No, I'm not, Your Honor, but I will probably be appearing on his behalf to local counsel.
Okay. Are you available on April 4th?
Judge, I do have a 9 AM in conflict in Cherokee County. Oh, no, I'm sorry. That's the third. April 4th is the second. Is that correct?
April 4th is the what?
Is it Tuesday?
Yes.
We are available.
Okay, good. All right, they'll set Mr. Gonzalez in each case for docket call on April 4th. It'll be at 9 AM, presumably in the same courtroom. Hopefully not, but presumably so.
Let's say, that's a little too long.
You'd be holding for a long time. You'd be holding for a really long time.
See you at 9 AM. Okay. Somebody here is not. So that's all we have for the board.
Yes, thank you, Mr. Estrada.
Thank you, Your Honor.
You're welcome, sir. All right, so what attorneys do we have left? I've got Mr. Lambert via Zoom on Joshua Davis. You want me to bring him in? Don't know anything about Mr. Davis. He's in federal detention. Let's bring him in. Well, he was there. He's not there anymore. Missed that target. So it's really Mr. Stevens.
Mr. Stevens was here, but
Really?
I don't know if he's still here or not, Judge, and Mr. Schmidt just went through, he has quite a stack of papers for us today. I believe that's pretty much it.
Give me that notice, Jack, if you know. I've already maybe been. Need to start bringing them on. Right? Mr. Carroll. This is cause number CR 21208. This is a sanctions court hearing. Mr. Carroll, I've got bad news for you. The state has filed a motion to revoke in your case. So we're not going to be doing the sanctions court hearing anymore. And this officer is going to take you into custody. And I'm going to set you for hearing on April 27th. Okay. Give him this, so they'll know it's court date. It's already taken him. It's already taken him. Because I may need to change that court date. Yeah, let me get that notice from me. I'm gonna give him a different one. I'm just gonna mark it and make it earlier and make it 3:30. It's 30th. No, 30. 30, yeah. Mr. Chavez, what'd you say?
I said, do I need to wait? Make any questions on Richard? Who's up there?
This is fine. Existing line. You can go ahead and take that, that's it, we don't need to take it over there, so. All right, this is the sanctions court hearing in CR 21-283. Giovanni Chavez Rosales, let's see, Mr. Chavez, it looks like you did your 30-hour community service, that's good.
Well, like, it's about that, man, I was gonna come for a pan and I was gonna come for a speech support on the last, what is it, 24th, I believe. But, I got in a car accident, my phone broke, I got a small injury with it. But nothing too tragic, I got the days wrong and, I didn't have a ride and stuff like that. And so I fixed my phone on the 26th, I believe, like on the Sunday side of everything, and that's why I got the message. Yeah, those goes on there. That's like my fault.
All right, well, I'm gonna give you a little bit of grace, okay? I'm gonna reset you to April 4th. And I need you to do your 3 sanctions or your three things you gotta pay. Yeah, you gotta pay $120 for probation. You gotta pay $120 to collections. And you gotta do 10 hours of community service. Okay, you're getting close to getting back down where you should be. Once we get you back down where you should be, then we can get you out of the sanctions court soon. Okay? Well, I appreciate that. All right, Mr. Chavez, sign right there. We'll have you come back on the 4th. All right, Lena Price. All right, this is sanctions court hearing at CR 21-88. All right, Mr. Price, let's see. You were ordered to pay $60 to probation, $65 to collections to do your 10 hours community service. And you did all those things. That's very good. What we're gonna do is, we're gonna reset you for another sanctions court. And we're gonna do the same thing. $60 to probation, $65 to collections, 10 hours community service. You do that one more time, I'm gonna release you from sanctions court. So you can just go back to being on regular probation without having to come to court every month for me to verify.
Yes, sir.
Okay?
Thank you.
You're welcome. We're gonna have you come back on April 4th. Alicia Joyner, Sanctions Court, CR 20127. All right, is Mr. Officer Material you in here? Okay, can we administer a UA on Ms. Joyner? That was the recommendation from your department. No? No, can you though? Okay. All right, so I'm gonna have you UA and then we'll do your hearing right after that, okay? All right, Joshua Chenault, CR 23-8. All right, Mr. Chenault. So understanding you're gonna hire an attorney? All right, and how long will it take you to hire an attorney? If I give you 30 days, you feel like we could have someone hired? All right, you're charged with burglary habitation, a second-degree felony, carries a range of punishment of not less than 2 years or more than 20 years in prison. Court's gonna reset you till April 4th. To give you time to hire an attorney and for arraignments. All right, Mr. Chenault. Mr. Waddell. This is Mr. Chenault. Has he checked in with you for pre-trial this? Okay. See Mr. Waddell, sign this paperwork, and then you'll be free to go. We'll see you back on April 4th. All right. Thank you. All right, Mr. Brewer. All right, we are back on the record in cause number CR 23-6. Mr. Brewer, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? Yes, sir. All right, so Mr. Brewer, I want to advise you, I don't want you to say anything about your case about the facts, anything that could be used against you at a trial. These are attorneys for the state, they're the prosecutors and the charge against you. So what we're going to discuss today are just some generalities regarding your right to represent yourself. Okay, so there's a few things that I have to inform you of. You are charged with the offense of theft of property with a value of greater than or equal to $2,500, but less than $30,000, a state jail felony. If convicted of that offense, you could face a range of punishment of not less than 6 months in prison or more than 2 years in prison. And a state jail prison system facility carries a day-for-day sentence, meaning there is no parole. Okay, you understand that? Let me make sure that there's no enhancements in your case. No enhancements, okay. And as I mentioned before, there are going to be technical rules of evidence and procedure, which you will be obligated to comply with if you represent yourself. You understand that?
Yes, sir.
And you understand that you will not be given special consideration because of any lack of legal education or training.
Yes,
You understand you'll be held to the same standard as the attorneys will be.
yes,
And you understand also that you have no right to have the court appoint you an attorney to stand by to assist you. You understand that?
yes.
Okay. Can you tell me a little bit about yourself? Tell me, how old are you?
I'll be 46, March 18th, 45 right now.
Okay. And what do you do for a living?
Recently I was a police officer for 26 years.
Okay. How recent was that?
Retired December 31st.
Uh,
2022.
2022
My college
with DPS? Okay. So you do have some legal education and training.
Yes.
You're not an attorney, is that correct?
No.
And so having that background with DPS, what's your level of education? You have a bachelor's degree?
No, high school.
High school.
If I could get into the academy, probably prior law.
Okay. And you understand that if you cannot afford an attorney, one will be appointed to you if you are considered indigent. That's your Sixth Amendment right to counsel. You understand that?
Yes, sir.
And you've considered whether or not you have the money. If you're indigent, you understand that you have the right to complete our paperwork. We'll evaluate what kind of money you make, what kind of expenses you have, and determine where you fall on that status. And you're indicating at this time that you don't wish to see the appointment of an attorney to represent you if you're indigent.
Yes, I said, I'm not saying anything about the case, why waste the county money, that is what it is.
Well, and what's difficult, and I understand, I can't say I understand what you're saying. I understand the statement. I don't know what the facts are of the case because I'm not privy to those. The state is, you are presumably. What I have to do is assure that your Sixth Amendment right is preserved, that is protected, but it is a right that you can waive. And so my job today is to admonish you as to the dangers of self-representation, the dangers of representing yourself in a court of law where you will not have the precise legal education, training, and experience to perhaps effectively defend yourself against a conviction, against the consequences of a felony conviction or a misdemeanor conviction, whatever may result, and the possible deprivation of liberty, incarceration. So that's my goal today. So I understand the sentiment of why waste the county's money, but the Sixth Amendment does not take into consideration whether that's a waste of money. It takes into consideration that if you are indigent, meaning that you financially are unable to employ an attorney, then the Constitution guarantees you that right to have one appointed to you. My recommendation before you embark on self-representation is to at least go through the paperwork to let us evaluate. If we evaluate your financial circumstances and we find that you're not indigent, then your decision becomes, You could ask the court to reset to give you time to accumulate money to hire an attorney, or to then consider whether or not to allow you to represent yourself. My advice to you is at least let us explore your indigency status. And then if you are indigent, the court could appoint you an attorney, and then you would have that legal advice. And the court, depending on your financial circumstances, could order that that attorney is to be reimbursed by you. The county pays the attorney, you can be obligated to reimburse the county for the legal fees expended on your behalf. Okay, so if you don't object to that, you have the absolute right to say, Judge, no, I understand what you're telling me, but I want to waive the right to an attorney. I don't want to hire an attorney. And I absolutely want to represent myself. That's also a right that you have guaranteed. My advice to you is let's at least look at whether or not you're indigent. And if you're not indigent, then, and you say, Judge, I still don't want an attorney and I still want to represent myself, then we've moved a little further down the line and we understand each other a little bit better. Fair enough?
Fair enough.
All right, so go see Ms. Abraham here. She's my indigent defense coordinator. She'll have that paperwork for you. Complete that. She'll bring it to me. We'll evaluate and I'll call you back up here shortly. Okay. Just came back.
Hello,
Hello, Mr. Lambert. Can you see and hear me okay?
I can see you now, yes,
Okay,
I apologize.
that's okay. This is cause number CR
I would-
22-372.
for hearing.
Joshua Lee Davis. We are set for arraignment. I show that Mr. Davis is in Henderson County and has a federal detainer. Is that correct, Mr. Lambert?
Yes, my understanding is he is in federal custody. He may no longer be in Henderson, but I don't know how they handle that in Henderson.
Do we have any information with regards to whether the charge here in Van Zandt County is the charge in which he's in federal custody on also?
No, I'm sorry, I didn't want to interrupt.
Go ahead.
That is exactly right. I had emailed your court coordinator and stated that I needed to try to find that out. I have limited experience with this particular issue, but it's always been my understanding that if it's the same exact charge, then the state will usually dismiss and he, will do his federal time. And if it's not, then this needs to get resolved or he's going to have to come home to it. Is that?
So let's do this then. Let's just reset the case for about 60 days, give you all time to try to chase down whether or not this is the same transaction, same offense. And then y'all can report back to the court. Are you available on May 9th?
I believe so, Your Honor.
All right, court will set Mr. Davis for custody status on May 9th. Mr. Lambert, let's do that at 1:30.
Very well.
That way, if he is in custody somewhere, he may end up in our custody. If he does, then we'll have all custody cases at 1:30. Okay.
Right, and I just got access to his discovery, so I will have reviewed that and done my due diligence by then.
Great, thank you, sir. All right, we'll see you back on May 9th at 1:30.
Thank you. Bye.
You're welcome. Have a good day.
For arraignment status.
I just putting putting arraignment in the status of custody. Ms. Joyner. All right, this is Sanctions Court hearing CR 2127 State versus Alicia Renee Joyner. Ms. Joyner, the notes in my file say that you continue to drink and you're not compliant with counseling recommendations.
I did go for alcohol a couple of times, but actually drinking. I did go to my 2 counseling sessions this last night, and I did community service and started catching.
Why are you just now doing that and you haven't been doing that?
The community service and bonds is, I'm a single mom with 3 kids and I have my own house and it's hard to have extra money.
Well, there's no complaint on your community service right now. It's more about
The classes.
the counseling and drinking.
I honestly like going to the women's counseling class on Wednesday nights better than I do the class on Tuesday nights. I'm more effective with it. It's not much to do. I just work a lot. I work the whole life.
I'm gonna have to I'm gonna have to sanction you for your drinking while you were on probation.
Understand.
So the sanction will be 3 days in jail. And I'll let you serve that on the 3 days that you pick, but they'll be consecutive days. So that could be a weekend, a Friday to a Sunday. Do you work?
Yes, I work.
Do you work Monday through Friday, or do you work on
I work. This, most time I have Tuesdays off, that's about it.
Tuesdays?
Tuesdays and every other Sunday, but this weekend and next weekend, we have like things going on at work. If I could do the weekend after that. then
I'm gonna let you pick the weekend with Officer Matura. You tell her the dates that you want to do it, and we'll let you do that.
Okay.
And so the drinking has to stop. The next stop could be prison. I mean, you're on deferred for a second degree. That's up to 20 years in prison. All right, get with Officer Matura, get those dates, and then I'll sign that. And then we'll reset you for a compliance hearing on April 25th. Okay. Awesome.
Yeah, if you want to do Andrews first, we ready. This particular, she had a debilitating toothache, so I put her on the top of my stack.
She does.
Yeah.
You want the Anders first, you said?
Yeah, well, I'll let you-
All right, Miss Anders, welcome back up. All right, back on the record, CR 22-351. The state has heard from Ms. Anders. We've set docket call on April 4th. Court found that had a note that Ms. Anders had not reported the pretrial release in February and was delinquent. The court had a urinalysis test conducted of Ms. Anders. Court has found that Ms. Anders has acknowledged consumption of marijuana and methamphetamine. Court finds that she has violated the terms and conditions of her pretrial release, and the court is going to find your bond to be insufficient at this time and place you back in custody. So the officers are going to take into custody at this time. All right.
Do you know what her bond is set at this point?
I think it was originally 10. I think it's 50 now.
50?
I think I'd have to look.
Yes, thank you.
I'd have to look on that order, but I can get that before too long. All right, so go ahead and go to the officers. $50, Richard. 50.
50, that's it.
All right, are you ready on Mr. Schmidt?
Ms. Williams.
Oh, yeah, Williams. Ms. Williams. All right, this is cause number CR 22-299, State of Texas versus Katie Renee Williams. Ms. Williams, I'm just saying you have a toothache, is that correct? All right, just speak as loud as you can. I don't want you to be in pain, but ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, lower your hand. Ms. Williams, are you a United States citizen who reads, writes, and speaks English? Have you ever been diagnosed with a mental condition? And can you tell me about that? Bipolar and PTSD. Are you currently on any type of medication or under treatment for that? Do you feel like you have a rational understanding of the proceedings that are going on today? Do you feel like your mental health condition in either now or in the past is in any way affecting your ability to understand what's going on here today? Mr. Schmidt, do you believe Ms. Williams to be competent today? Have you seen any evidence of any mental condition that would impair her competency or understanding?
No.
All right, Ms. Williams, you are charged by indictment with a state jail felony offense of theft of property greater than $2,500 but less than $30,000. A state jail felony carries a range of punishment if convicted and sentenced of not less than 6 months in prison or more than 2 years in prison, and a optional fine not to exceed $10,000. Do you feel like you've had enough time to discuss this case with your attorney, Mr. Schmidt? Are you pleased with Mr. Schmidt?
Yes.
You have any questions about the paperwork that you signed today? You understand everything that you've read and signed? I see that the plea agreement is that you would plead guilty to that charge in exchange for the state's recommendation that the court review the evidence, withhold a finding of guilt, place you on deferred community supervision for a period of 3 years with a $1,000 fine plus court costs and reimbursement fees. And the state would be dismissing another theft of property case in conjunction with this plea. Is that your understanding of how the cases would be resolved? And that's what you're asking the court to approve? All right, then Ms. Williams, I'm going to ask you at this time, how do you plead to theft of property greater than or equal to $2,500 but less than $30,000? Are you pleading guilty because you are guilty of committing that crime? Has anyone threatened, forced, or pressured you to plead guilty? All right, the court will accept the defendant's plea of guilt. Mr. Schmidt, any objection to the state's evidence?
No, sir.
State's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Yes, Your Honor, just briefly, that, in regards to restitution, the, victim received the stolen property back, so there is no restitution. request.
All right, thank you, Mr. White. Anything further from the defense?
No, sir.
All right, the court's going to review the evidence. All right, the court has reviewed the evidence, finds that there is enough evidence to convict Ms. Williams of this offense. The court will follow the plea agreement. Court hereby defers the finding of guilt. Places Ms. Williams on deferred community supervision for 3 years. Orders her to pay a $1,000 fine, $290 court costs, $535 reimbursement fees. The court will dismiss under section 1245 DA 2022-702 theft of property greater than or equal to $100 but less than $750. All right, Ms. Williams, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department, so they carry out the terms and conditions of the sentence. I'm gonna have you step up here with Deputy Woosley. He's gonna take your fingerprint. After that time, you'll need to talk to the probation officers and they'll give you more information. Nisha Williams. Is it Kanisha or Kanisha? Kanisha, okay. Sometimes I get it right, sometimes I miss it badly. All right, this is cause number CR 22199. Ms. Williams, if you'll raise your right hand, I'm going to place you under oath, ma'am. You swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth. So help you God.
Yes, sir.
All right, you can lower your hand. Your name is Kanisha Lynette Williams, is that correct?
Yes, sir.
And Ms. Williams, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
Yes, sir.
Can you tell me about that? Okay. Are you under treatment or on medication for that? Do you feel like that in any way is affecting your ability to understand what's going on here today? Okay. And in this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt as your attorney?
Yes, sir.
You feel like you've had enough time to talk with him about your case and have all your legal questions answered?
Yes, sir.
You signed some paperwork here today. Do you understand everything that you've read and signed?
Yes, sir.
Mr. Schmidt, do you believe Ms. Williams to be competent? And you explained her rights as they pertain to this plea and the advantages and disadvantages of a deferred adjudication. All right, Ms. Williams, you are charged by indictment with a first-degree felony offense of manufacture or delivery of a controlled substance in felony group 1, greater than or equal to 4 grams, but less than 200 grams. That first-degree felony carries a range of punishment of not less than 5 years in prison or more than 99 years or life in prison if you were convicted of that offense. I see that the plea agreement in your case is that upon a plea of guilt, the state would recommend that the court review the evidence, find that there is enough evidence to convict you, but not convict you and defer a finding of guilt and place you on community supervision for a period of 5 years, order a $1,500 fine, $290 court costs, reimbursement fees, restitution fees, and it appears the state would be dismissing 5 unfiled cases and also a weapon forfeiture. Is that your understanding of the plea in this case? Any questions? All right, is that your understanding of the plea agreement?
Yes.
Okay, all right, then Ms. Williams, understanding the plea agreement and the admonishments, you still wish to go forward?
Yes, sir.
All right, Ms. Williams, how do you plead to manufacture delivery of a controlled substance in penalty group 1 greater than or equal to 4 grams, less than 200 grams? Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty today? All right, the court will accept the defendant's plea of guilt. Mr. Schmidt, any objection to the state's evidence?
No, sir.
State's evidence supporting the plea is admitted. The court takes judicial notice of Ms. Williams' judicial confession. Anything further from the state,
No, Your Honor, we rest both the same.
from the defense? All right, court's gonna review the evidence. All right, the court has reviewed the evidence and finds that there is enough evidence to convict Ms. Williams of this offense. The court will follow the plea agreement. The recommendation of the state court hereby refers a finding of guilt for Michelle Annette Williams, places her on 5 years deferred community supervision, orders her to pay a $1,500 fine, $180 restitution, and the court will dismiss under section 1245 all cases outlined in the paperwork. And the court orders her to pay $535 reimbursement fees, in addition to $290 court costs. Ms. Williams, you hereby remanded to the custody of the Community Supervision Department so they can carry out the terms and conditions of the sentence.
Judge, did we order the weapon forfeiture?
Yes, court will also order the weapon seized, specifically a Taurus International serial number ACH 134458 to be forfeited as the defendant has been prosecuted for an offense involving use of a weapon under chapter 46 of the penal code. Court orders the weapon to be forfeited to the state of Texas to be destroyed or used by the law enforcement agency. All right, Ms. Williams, if you'll come forward, so Deputy Woosley can take your fingerprint. After that, then you'll meet with the probation officers, okay?
Okay.
It's a little slow.
Michael Tubbs, CR 22-296. All right, you Michael Cole Tubb. Mr. Tubb, if you'll raise your right hand, I'm going to place you under oath. This is call number CR 22-296. Mr. Tubb, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth? So help you God. All right, you can lower your hand. Mr. Tubb, are you a United States citizen who also reads, writes, and speaks English?
Yes.
Have you been diagnosed with a mental condition before?
Yes.
Can you tell me about that? Are you on medication for any of those?
No, sir, I live in the state of Georgia, so I can take my medication.
Okay, and are you under a doctor's care at all?
No.
And do you feel like you're suffering from any of those conditions today? Do you feel like any of those have prevented you from having a rational understanding of these proceedings and the case against you?
Yes.
Okay. In this case, you are represented by your attorney, Mr. Schmidt. Are you pleased with Mr. Schmidt as your lawyer? Yes. Do you feel like you've had enough time to talk with him about your case and that you've had all your legal questions answered?
Yes.
The paperwork that you've read over and signed today, is there anything about this that you do not understand? Mr. Schmidt, do you believe Mr. Tuck to be competent?
I do, Judge, I physically with my notes, things or anything that gave me pause or belief that. Before we go and proceed.
Okay, and you've also explained to him his rights that he's waiving and the advantages and disadvantages of the deferred adjudication plea.
I have,
And you believe he understands all those?
I believe in
All right, Mr. Tuff, you are charged by indictment with a third-degree felony offense, which carries a range punishment of not less than 2 years in prison or more than 10 years in prison if you're sentenced and convicted and sentenced on the charge of evading arrest or detention with a vehicle. Do you understand that? If the court were to approve this agreement today and you were to be placed on probation, if any violations of your probation conditions occur, the court can conduct a hearing, hear the evidence. If the court finds that you violated any of those, the court will do a number of things. One of those being the court could revoke your community supervision, convict you, and sentence you anywhere between that minimum of 2 all the way up to the maximum of 10 years in prison. You understand that?
Yes, sir.
And understanding that, you still wish to go forward?
Yes.
I see that the plea agreement is for 4 years community supervision, a $2,500 fine plus court costs and reimbursements. So understanding both of those things, Mr. Tuff, how do you plead to evading arrest or detention with a vehicle? Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened you, forced you, made you feel like you had to plead guilty? Okay, the court will accept Mr. Tuff's plea of guilt to this charge. Mr. Schmidt, any objection to state's evidence?
No, sir.
State's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor, we're Mr. Boss.
Anything further from the defense?
No, sir.
All right, court's going to review the evidence. All right, court has reviewed the evidence. The court will follow the plea agreement between the state and the defense. Court hereby defers the finding of guilt. Places Mr. Tuff on 4 years community supervision, orders him to pay a $2,500 fine, $290 court cost, and $535 reimbursement. All right, Mr. Tuck, you hereby remanded to the custody of the probation department, so they can carry out the terms and conditions of the sentence. I'm going to come up to be fingerprinted with Deputy Woosley, and then the probation officers will give you more information about what's next. Okay?
Yes, sir.
All right, Nathan Capital. This cause number is CR 22-220, CR 22-231. And also cause number CR 22-231.
Judge, we we inadvertently, Mr. Schmidt just informed us we forgot the dismissal on
221.
221. We're putting that out now, and we will submit to the court. We
Thank
are,
you.
in conjunction with the plea, we will be dismissing.
Okay, that's what I was looking for. All right, Mr. Capfield, if you'll raise your right hand, sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, John.
All right, thank you. So you lower your hand. Your name is Nathan Allen Capfield, is that correct?
Yes, John.
And Mr. Capfield, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
I felt like that.
Okay, are you on medication under a doctor's care for that?
Yes.
Okay, do you feel like you have a rational understanding of what's going on in this case today? And you're represented by your attorney, Mr. Schmidt. Are you pleased with Mr. Schmidt as your attorney?
Yes.
Feel like you've had enough time to talk with him about your case and have all your legal questions answered? Anything about the paperwork that you've read and signed today that you don't understand? Mr. Schmidt, do you believe Mr. Capfield to be competent today? When you've explained to him his rights as they pertain to these plea agreements and also the advantages and disadvantages of the deferred adjudication plea?
Yes.
And you believe he understands all of those rights and the waivers that he's making?
Yes.
All right, Mr. Capfield, in CR 22-220, you're charged by indictment with a third-degree felony offense of prohibited substance or item in a correctional facility that does carry a range of punishment of not less than 2 years in prison or more than 10 years in prison if you were convicted and sentenced. And you could also receive a fine up to the maximum $10,000. In cause number CR 22-231, you're charged with a Class B misdemeanor offense of driving while intoxicated. That carries a range of punishment of not more than 180 days in the county jail and then fine, if imposed, of not more than $2,000. I see that the plea agreement in your felony charge is that you would plead guilty to that prohibited substance charge. The state would recommend that your guilt be deferred. That means that you not be convicted of this offense, that your punishment be assessed at 2 years community supervision, a $1,400 fine. They would be dismissing a terroristic threat, a duty on striking a fixture or highway landscape, theft of firearm, and unlawful carrying of a weapon. In addition, you would have court costs and reimbursement fees. In your DWI case, it appears that the recommendation is that you would plead guilty to that charge. The state was the original charge something higher than the DWI one?
It was originally DWI 2.
Okay. That the terms of your agreement would be that the original charge of DWI 2 be reduced to DWI 1. Your punishment would be you would be convicted of that offense. You'd be punished for 3 days in the county jail. You would get credit for all 3 days. And then you would pay a $100 fine plus court costs and reimbursement fees. Is that your understanding of how your cases will be resolved today?
Yes.
And that's what you want the court to approve?
Yes.
All right, then, Mr. Capfield, then how do you plead to prohibited substance or item in a correctional facility? How do you plead to driving while intoxicated? Are you pleading guilty to each one of these crimes because you are guilty of committing each one of these crimes?
Yes.
Has anyone threatened you, forced you, pressured you to plead guilty to either crime? All right, court will accept the defendant's plea of guilty in each case respectively. Mr. Schmidt, any objections to the state's evidence supporting each plea?
No.
State's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Just for the court's information, the substances that Mr. Capfield took into the jail or his prescribed medications, hence our plea. He's not allowed to do that, obviously it's that, but that is why that is the basis for that. Also, through my discussions with Mr. Schmidt, obviously the thrust of a lot of this was the cases being dismissed. After reviewing the case, I don't believe the officer sentence what Mr. Capfield actually said. You will see in there that there is some language that is very concerning, but after watching the video, we don't believe that's actually what it said. It just sounded similar to that. So that is why we're proceeding with this.
All right, thank you, Mr. Wright. Mr. Schmidt.
I would concur with that analysis.
Okay, all right, court's going to review the evidence. Were y'all able to discern what he did say?
Yes. Yes, it involves on something about dope and not anything about. It's not you saying that he's on dope, it's regarding drugs, dope, and like, not you saying he's on dope.
I'm assuming that y'all had this discussion with the trooper that,
Judge, if I may, the trooper report and the visual evidence, the trooper who was the victim of terrorist threat did not hear Mr. Capital say that. It was another officer who was in proximity who claimed he had said, "Mr. What did you say?" And immediately upon being asked, Mr. Capital responded, said, "I thought he was on dope." And he said, "That's not what I thought you said." And he said, "Yeah, I thought he was on dope, but he was around." So then that particular officer stated to the trooper who said on tape that he didn't hear it. That when he goes, "Well, I have it on my body cam, so it'll be on there." It's on. We looked for the body cam video of that officer who claimed that Mr. Capital had said what he claimed to have said. And it's not in existence. And so ultimately, they were within arm's distance of each other. And he didn't say it.
okay,
That's my, as an officer in the court, we have to quite carefully make sure that that witness is.
okay, I do appreciate that. All right, and then based on the court's review of the evidence, the court finds that there is sufficient evidence to convict Mr. Capital of each one of these offenses. The court will follow the plea agreement in each case. In cause number CR 22-220, the state hereby defers the finding of guilt on prohibited substance or item in a correctional facility, places Mr. Capital on 2 years community supervision, orders him to pay a fine of $1,400, court costs of $290, $535 reimbursement fees. The court dismisses under section 1245, CR 22-231, terrorist threat, DA 2022-130, duty on striking fixture highway landscape, DA 2022-131, theft of firearm, and DA 2022-128, unlawful carrying of the weapon. CR 22-231, court, based on the evidence, convicts Mr. Capital of driving while intoxicated. First offense, assesses punishment at 3 days confinement in the county jail, gives him credit for 3 days time served, orders him to pay a $100 fine, $270 court cost, and $35 reimbursement fees. All right, court hereby remands Mr. Capital to the custody of the probation department, so they can carry out the terms and conditions of the sentence. Mr. Schmidt, I'll need you to sign this certificate of discovery here. All right, Mr. Capital, if you'll come forward to be fingerprinted with Deputy Woosley, then the probation officer will tell you the next step. Yes, sir.
Speak to real quick and Mr. Ricky, did you pick one? You want me to go ahead and just get those knocked out, or do you want to bring them back and what's your?
Yeah. That's what.
15 minutes? Sure. Richard is
All right, for purposes of NISI, the court has called the following names. They were not present at 9 a.m. They were not present at this time, which is approximately 12:15. In the afternoon, their names have been called loudly and distinctly 3 times in the courthouse with no response. The court hereby issues alias capias and law enforcement judgment on Michael Scott Patterson, CR 2315. Joseph Paul Cronin, CR 22322. And CR 2275, John Daniel Piercefield. Court's going to stand in recess for about another 5 or 10 minutes to allow Mr. Schmidt to talk to his comments. All right, court calls. Cause number CR 23-6, State versus Brad Andrew Brewer. Mr. Brewer, you'll come up. All right, the court has called this case, had discussions with Mr. Brewer about his request for self-representation. The court admonished Mr. Brewer regarding his Sixth Amendment right. Court has asked Mr. Brewer to complete the application for court-appointed counsel. Mr. Brewer has done that. Court would find Mr. Brewer to be indigent with ability to reimburse the county at this time. Court's understanding is that Mr. Brewer is accepting of that appointment of court-appointed counsel. The court has appointed Honorable Richard Schmidt. And Mr. Schmidt, Mr. Brewer is set for arraignment today. Have you had an opportunity to read the indictment?
We have a real judge, Spurs main spot, we understand this charge. We wait for the reading, that's. We said the pre-trial and it's fully not guilty.
All right, the court will enter Mr. Brewer's plea of not guilty into the record. We'll set this matter for pre-trial hearing. Do you want something a little later than April 4th?
Yes, sir. Yeah, maybe 9.
May 9th?
Yes.
All right, court sets Mr. Brewer for pre-trial on May 9th. That'll be at 9 a.m. probably in this courtroom.
Maybe it's you.
Yes, sir, you're excused.
Thank you. And so when we,
You're gonna bring Mr. Reedy in here and I'll just tell him, you want him back here at 1:30?
yeah.
Bring him in and I'll order him. What time are we,
2 and 2:30 are our Spanish.
so we'll need to get there early enough to get all that.
Oh,
stuff.
yeah, I'm gonna take number 2.
You're gonna say like 1:50 or something, 1:45? If you don't have time, I'll order it.
Dairy Queen's fast. It's
Oh,
Taco
Taco
Tuesday.
I'm gonna have cereal today. I think.
Huh?
I'm gonna have cereal today.
We don't want wine, so.
We can bring,
Raisin Bran Crunch. No,
we can bring tacos.
I've already bought the Raisin Bran. Already paid for it. All right, this is cause number CR 2307 and CR 2337, State versus John Brendan Rigney. Mr. Rigney, Mr. Schmidt says that he's still working on your case, so I'm gonna order you to come back to the courtroom. Just be back here. Mr. Schmidt, you wanna take care of this first or your inmates first?
I'm not gonna go ahead and take care of this first. I've got a bunch of this.
Okay, so Mr. Rigney, be back here by 1:45. Okay. All right, then the court will stand in recess till 1:45 for the afternoon docket.
Okay. Yes, sir. Yeah.
First, and then also.
I use from the